We normally would take a coffee break at this time, but we're going to press on through and hand the next two cases in order. And the next case is Modern Inc. versus John C. Cunningham. The Sadie Baker case has been rescheduled. You want to reserve any time, counsel?
If I may, 5 minutes, Your Honor.
You got it.
Thank you. May it please the Court. My name is Christopher Coleman. I'm here on behalf of Modern Inc. This case comes to court after a jury trial before Judge Dugan on June 5th and 6th of 2006. The nature of the case essentially boiled down to, by virtue of the final judgment, a breach of contract, a vendor-vendee contract.
Counsel, the three of us are all familiar with the facts. We've read the briefs and studied the records, so if you want to jump right in on your arguments, you can
jump right in.
Do it with confidence that we understand what you're talking about.
Very well, Your Honor. Jumping right in, not necessarily in the order in the briefs, but jumping first to the statute of limitations, which I think is probably the most relevant and frankly, the strongest argument. What it appears we have here is the trial court, in an effort to help a victim, if you will, mixed the delayed discovery and tolling of fraudulent inducement in arriving at a date that was inside of the statute of limitations, when it is clear that, as framed by the pleadings and the evidence, this was a straightforward breach of contract. And the breach occurred in January of 1991, when deeds were in fact recorded and the property was conveyed. The plaintiff and the trial court apparently agreed with it, bought into this, but there's this title dispute and there's a dispute as to who's owed the money. The problem being is that is not relevant to the breach of contract action at hand here. And the statute of limitations clearly ran sometime in 1997, January of 1997.
Let me ask about it. Wasn't there an agreement that the money would be placed in escrow, whether it be with an agreed-upon person or the clerk of the court, so that your client wouldn't be in the position of paying money to either the appellee or to Ms. Fox, and run the risk of having to pay the money twice? I mean, wasn't there an agreement? Your client wasn't sure who to pay the money to because of a dispute going on between the appellee and this Ms. Fox. And your client agreed to have the money placed in an escrow account until that matter was resolved.
Potentially, and I want to clarify a little bit because the facts got a little muddied. Let me answer it first. Even if you want to believe that 1995 settlement agreement with regards to the placement of escrow funds, and the Modern would submit that there's been 3 separate escrow agreements. That's the only one that was in writing that was presented. That agreement was in 1995. If, in fact, that agreement was breached, it was breached when the funds were not placed with Mr. Starling, and therefore that breach occurred.
Why wouldn't that be a fraudulent concealment if Starling consistently, and taking the facts in the light most favorable to the other side, which I think the trial court found that Starling was the agent of your client only. I mean, that's the way I understand the trial court's finding. Why wouldn't that be fraudulent concealment if Starling, who was the agent of Modern, sent statements to the other side saying consistently, I have the money, here's the interest, and I mean,
your question presupposes that in fact, John Starling was the agent of Modern in order to say that fraudulent inducement applies. But addressing it backwards, fraudulent concealment. Fraudulent concealment does not apply in contract cases. Fraudulent concealment is a potential for the tolling of a statute of limitation as opposed to delayed discovery. And the tolling of statute of limitation is only appropriate in instances enumerated within the statute. There is no statutory enumeration for fraudulent concealment in breach of contract cases.
Didn't they allege a fraud cause of action as well?
They allege a fraud cause of action, yes. But the fraud cause of action was not, they did not prevail in the fraud cause of action. It was not sufficiently proven. So with regards to that, there is no concealment. To the extent that they've kind of muddied it and suggested that maybe it was delayed discovery, again, this court has held that delayed discovery is not appropriate in breach of contract.
Well, why wouldn't the cause of action, if they reached an agreement that the money did not have to be paid until the dispute between Ms. Fox and the appellee had been resolved, why wouldn't that be the time when your client had the obligation to pay, regardless of whether the money was put in escrow or not?
Because, again, I think the court's confused as to what parties were that agreement. There was a third cause of action, a third element of the claim that was there was a breach of this 1995 settlement agreement, which discussed the escrowing of funds. The plaintiff below, Ductile, was not a party to that. They had pled a intended third-party beneficiary cause of action for that. If you believe that that's the contract that they were prevailing on, which is not the contract Judge Dugan found for them on, the contract was the vendor-vendee contract. If you believe, then again we have the lack of standing argument, because the parties to that contract were the estate of Robert Fox.
Well, let's talk, well, I'm jumping back, I guess. The issue one, the standing issue,
yes,
since you just raised it, would you concede that issue in light of Plaintiff's Exhibit 3, the contract that Ductile actually directly entered with your client?
Absolutely not. And the reason being is the other exhibits, including the assignment, understanding the history of how what I've called Ductile Florida, which is Ductile Limited, a Florida limited partnership, acquired its interest subsequent to the contract. The contract was executed in January 30th of 1990, actually signed by Ductile Florida January 31st, 1990. Ductile Florida didn't obtain its interest from Ductile Cayman Islands until March 23rd, 1990, exhibit number 2. So it was
Are you saying a successor in interest can't sue based on the original? I mean, if there's simply a successor in interest and Ductile, whoever, Cayman Islands, was a direct party to the contract, why wouldn't its successor have a cause of action for breach of contract?
That's what I'm trying to make clear. Ductile Cayman Islands was the holder of the interest in the trust at the time of the signing of the contract.
I mean, your argument was that only the trust has a cause of action.
The trustee.
The trustee. And then the appellee argues, and it seems correct to me, that, well, if you look at the record, each individual beneficiary was a contracting party, and each individual beneficiary also signed a deed directly to the appellant.
That is correct, they did.
Okay.
But again, the plaintiff did not, well, the timing is appropriate if you're going to go down that path of believing that the mere fact they signed this contract, and it would be our position that it was executed out of convenience because of the murky nature of the trust, and while it may be a title requirement, it does not create a cause of action, it does not create a breach of contract.
Under what theory do you not have a potential contract cause of action if you're a party to a contract? I just...
Because they didn't actually convey anything under Chapter 689.
But they gave your client a deed.
Absolutely. The mere fact they gave a deed that is superfluous doesn't create a cause of action or create a contractual obligation. Under both 689, the land trust statute, title vested in the trustee, and...
I guess it's your theory that if you sign a contract that's unnecessary, you can't sue under the contract because it was unnecessary?
Absolutely. And I believe
You have a case that...
Well, I believe it was illusory. There's nothing to convey. And in fact, if Modern had brought a cause of action for some sort of specific performance or breach, it would be found that it was illusory. There was nothing that, in fact, Ductile, especially who signed the contract, Ductile Florida, who didn't even own any part of the trust at that point in time. It was not in ownership at that point in time, didn't own anything. Therefore, they could not have had a cause of action under the breach of contract. It was an accommodation for the closing agent only. And both 689 and 727, as cited in the brief, state that it's vested with the trustee. Therefore, that would be the only one that can have a cause of action and is the only one conveying something. It's not like where we have an operation of law where we have a homestead property, and although...
Even if you're correct, and I'm not sure that you are, wouldn't Ductile be an intended beneficiary, and can't an intended beneficiary sue for breach of contract?
Under an intentional, potentially yes, but not under the trust document that they presented. Under the trust document that they presented, their interest was personal only. Personal property only. Their ownership, their 14.18% interest in the trust. They had an interest in the proceeds. The fundamental problem with this case was their cause of action was against their trustee. Their trustee dispersed proceeds, received all the proceeds, and dispersed to every other beneficiary.
You're saying that Starling was
No, the only testimony, there's no testimony from Ductile or the general partner, Mr. Cunningham, that in fact the money was not paid. The only testimony is from the representative of honor, said all the money was paid and that it was provided to Mr. Dreiling, attorney for the trust. And in fact, Mr. Cunningham in his testimony said, I had a conference call with Mr. Dreiling, Mr. Starling, and I was told by Mr. Dreiling the money would then be sent back, it would be held by Mr. Starling. But all the money was to be received by the trust and was received by the trust and then was redispersed. And the other problem we have here is...
Did your client cut one check to the trust, or did your client cut separate checks to each beneficiary?
Cut no checks to the beneficiary. There's no testimony to answer your question, multiple checks. It was not one check. But no check at all from Modern to the beneficiaries. And in fact, it's important to understand the January closing actually occurred with cash and a seller mortgage of $800,000. That mortgage was then satisfied in the second closing in August 1991 when all of the issues were resolved. So the fact is, it closed in January of 1991, and they're trying to backdoor now apparently a failure to satisfy mortgage because there was no testimony or evidence presented with regards to what portion of that mortgage may have been done or not done.
And maybe I'm missing something, but I don't even remember these arguments. I mean, it seemed to me that it was completely understood that this money was never paid to anybody. And that's why Starling, except to Starling, and the question is whose agent was he, but I mean, it seems clear from the documents in the record and everything brief that I read that everybody understood that this money was never paid because it was disputed as to who it was going to be paid for. It was placed with Starling, and Starling sent statements throughout the entire term to both parties saying this is the interest. And then when they went to get the money, Starling said, well, I put it back with your client.
Well, you're confusing. It's undisputed. By us, we have no ability to show otherwise, that Ductile did not receive its distributive share from the trust. It is not undisputed that it was not paid, as you've just said. That is mischaracterization. It was paid, and the only testimony is that all $2 million was paid. First, $1.2 million and an $800,000 mortgage, and then in August, the $800,000 mortgage was resolved. That is the only testimony. Mr. Cunningham said, I have no idea what was paid, when it was paid, by who was paid. I was not involved in any way whatsoever. Mr. Manley, the president of mine, said it was all paid. What is getting confusing here is, like I said, we had 3 escrow agreements. We had an original escrow agreement in January of 1991 when
Why would there be an escrow agreement if all the money was paid?
Because it was to not be dispersed. There was a question as disbursement.
But all the correspondence relating to those escrow agreements talked about your client putting the money with an escrow agent. Why would your client even discuss that if your client had already paid all the money to the trustee?
Because I'll explain. What was happening was the money was first escrowed as a result of 2 title defects unrelated to Barbara Fox and Mr. Cunningham. They were the Rondinelli and Kearns tax issues, and those were what caused the first seller mortgage, because those funds were bonded off. And in fact, Mr. Cunningham put money into to help bond off, put money into the pot to bond it off. That was in January. In May, between the time of that closing, title being conveyed to Modern, Ms. Fox came out and created a title dispute. That title dispute is the escrow agreement in the 1995. So that's why they were involved. They were involved because of a second title dispute under their title policy.
Okay, you haven't answered my question. My question is, why would your client agree to place money with an escrow agent if your client had already paid all the money it owed under the contract?
Because of what I'm explaining.
I'm not getting it. I mean,
The title dispute that arose after.
so there's a title dispute. If your client had paid all the money, why would your client say, okay, I'll place money with an escrow agent? Because I mean, doesn't that presuppose that all the money wasn't paid?
No, I'm having trouble with you saying not paid but escrowed. The fact that it was escrowed pursuant to the request of Mr. Dreiling, who was the attorney for the trust because of disputes with his two beneficiaries. Modern had nothing to do with that. It is only when the title dispute came up, Modern said, hey, look it, we don't care where it goes. We really don't care where it goes. We're done with this as long as the title dispute that arose, and we are funding additional money for that related to the title dispute.
Are you saying that the trustee gave the money back to Starling?
I'm saying the trustee agreed. There was no evidence below that presented one way or the other whether it went there and back, because unfortunately Mr. Dreiling had passed away as well. And I will reserve it.
Yeah.
Good morning.
Good morning.
Morning.
My name is Brian Duchel from Fort Lauderdale, Florida, representing the appellee in this matter. The case is a simple one because all of the facts that drive the appellant's arguments are already resolved because he's waived any judicial review with respect to such facts. We state in our answer brief that the appellant waived its rights to evidentiary appellate review because it failed to renew its motion for involuntary dismissal at the end of the evidence. And we cite cases in support thereof, basically Thompson versus Florida Cemeteries, Day versus Amity, and the Plaza case, all of which state that that is the case. So when he comes before you and he says, look, these facts should have been determined in a different way. There wasn't any value. The escrow agent said this or that, or whatever is his basis. And every one of his arguments are fact-driven, including the statute of limitations argument. He's got no standing in this court to have this court review those facts to make that determination.
Well, if he's raised the statute of limitations, for example, are you saying that he has to do a motion for directed verdict on the statute of limitations issue? Or can we review whether the judge correctly?
I do in the event that the statute of limitations is determined by the facts that he's arguing. The judge has determined as part of the final judgment that the breach occurred in 1999. That's a factual determination. That factual determination, which is stated in the judge's order, is binding if he didn't renew.
But I'm not, if it's an error of law, we can review it. I'm not saying it is an error of law, but I think you're probably better off, at least with me, addressing the three issues on the merits. Let me ask you first of all, my understanding on the issue of whether Starling was the escrow agent or not. Your client said there had been no agreement to Starling, and they had a witness that testified there had been agreement. Is that pretty much it, too?
Well, Judge Harris testified, yes, he talked to Starling, who's dead at the time of the trial.
So there was competent evidence to support either way. If the judge had said the parties agreed to Starling, there was competent evidence to support it. If the judge believed one person over another and said that there was no agreement to Starling being the escrow agent, there's evidence to support that as well. Is that correct?
That's correct.
Okay.
The judge ruled that Starling had a lot of hats on. And if you read the final judgment, it'll state the number of hats, which I think I've written down here. One, he was the closing agent. Two, he was the escrow agent. Three this is the judge making findings of fact, that he was the escrow agent, he was secretary of the company, he signed the contract, that he signed the contract as president, that he signed the August 12th closing statement as vice president of the company. It's replete.
How would you address the standing argument?
The standing argument really doesn't compute because of two things. One, there is a contract. It's a signed contract. He said, well, he didn't have anything to sell. Doesn't make any difference if he did it. I'll take exception to that, and there's no facts in this record that upholds that statement that he's made. Absolutely, you won't find anything about where they said, oh, he didn't own the property. It's not there.
Who signed the deeds? Did both the trust and the beneficiary sign the deed?
Yeah,
And did the trustee also sign the contract?
yes. And look at the closing statement. The closing statement is a statement which is signed by the buyer and the seller, and it states who gets the money, right down to the 14.89% or whatever it is that Mr. Cunningham and Ductile was supposed to get. That is an agreement which, in and of itself, which called privity. So I'm going to pay you this money. You're entitled to it. And the judge so found. I think his standing argument fails just on its face. The contract, closing statement, the escrow agreement. There was another escrow agreement, not the Fox and Modern agreement, which was when Mrs. Fox finally decided that Mr. Cunningham and Ductile were the real parties of interest and were entitled to the 14.89%. It was another agreement where they said, okay, well, we'll pay you this money, but we won't pay it until that 1999 determination is made. And in 1999, they made the determination, and that is when Mrs. Fox finally settled with Cunningham, pursuant to a separate agreement, and under that agreement, she conceded the fact that the money should be paid. So what did Mr. Cunningham do? He went over to Mr. Starling and said, pay me the money. Look, Mrs. Fox has no more interest in this matter. And Starling says, no, I haven't got the money.
Why was the argument ever made that Starling may have been a dual agent of your
Yes,
client?
they made that argument. They made that argument. The judge didn't buy it. I think that we're bound by what the judge decided in that regard. And there's plenty of evidence to support what he did. I find that this appeal just doesn't match the facts of the case, and that the law, if you apply it, he adds to the statute of limitations. The breach occurred. He decides when the breach occurred. It's based upon facts. They didn't renew their motion for involuntary dismissal of this case at the close of all evidence. They cannot prevail in this case, and this court should not rule that they...
Did Mr. Cunningham testify that he had not agreed to Mr. Starling being the escrow?
Yes.
The trial judge found that he was credible?
That's right. Thank you, gentlemen.
Wait, was it undisputed that Modern paid the entire closing amount, gave all the money to Starling, and that Starling did not disperse any money related to Ductile's interest? Are those the facts?
Well, what they did, there was $224,000. They gave $24,000 of it, which they were going to use for expenses, to drive it. The $200,000 went to Starling.
Mr. Coleman represented that the testimony was undisputed, which is not in their brief, but the testimony is undisputed that Modern paid all the money to the trustee and doesn't know what happened to it after that.
There's no evidence that I know of in this record where all the money was paid to the trustee.
That you said.
And the judge doesn't so find.
Okay.
Thank you, counsel.
If I may clarify the issue, Judge Lawson, if I said that, I misspoke.
That's what I understood, so I may have missed.
There was no testimony that Modern paid directly to the trustee. Absolutely not.
Okay.
Everything was done through the closing agent, Mr. Starling.
Who was president, incorporator, and everything else?
Not president at the time. He was incorporator. The only testimony was long since resigned as president. He was the incorporator originally of Modern. He did sign the contract for sale and purchase.
As president?
Either president or vice president, as an officer. I don't recall if it was president or vice president. And then but that contract was a year old. So during that year, he had resigned because it didn't close until 1991, even though the contract was 1990.
Did the closing agent cut checks to each beneficiary?
No. There's no testimony closing agent cut checks to the beneficiaries.
We're talking about Starling.
Yes.
Okay.
Judge Evans?
Well, you say there's no testimony. Is there testimony either way?
I don't believe so, to be candid. There was some vague recollection by Mr. Maley that Mr. Starling received money, and there was some payments made during the January closing directly to Mr. Starling, what we called during the trial the soft closing or the escrow closing. But in the January closing, checks were made and delivered directly to Mr. Dreiling and bypassed Mr. Starling altogether. But with regards to most of the proceeds, they went from Mr. Starling to Mr. Dreiling.
And they bypassed the trustee as well.
Well, what Mr. Dreiling did with them after that, we don't know. We don't know who paid the beneficiaries, who
Right, but
disbursed the money.
Starling did not cut the $24,000 check to the trustee.
Yeah, I don't recall where the $24,000 went, Your Honor. To be candid, I do not recall.
Because it just seems to me that if all these beneficiaries sign the contract and they all sign the deed, and your client signs the contract, and I understand your argument that it's not consistent with the trust agreement, but if all the parties choose to ignore the trust agreement and deal with it as if all these people are selling the property individually or covering both bases, why shouldn't the trial judge follow the parties' actions?
Because then we're in the issue here is now we're invested in their trust, so to speak. While every one of them signed it, what were each one of them giving? What percentage of the property? Modern doesn't know. Modern merely said, you guys tell us who your people are, get them all to the table, get your act together. Do we know it was 14.18? Do we know it was 12? Do we know it was 10? Do we know whether or not their trust interests had been encumbered or not encumbered? No. At no time did the buyer, Modern, agree to that. I want to get really quickly because I am running out of time. You asked the question of whether or not Cunningham agreed. There was testimony Mr. Cunningham agreed to John Starling. The answer is absolutely yes. At page 50.
Well, there's testimony did, but there's conflicting testimony, correct?
No. There's no conflicting.
Mr. Cunningham never said that he didn't agree to it?
Absolutely. He said he agreed to it. He kept saying reluctantly, but he kept agreeing to it. Initially,
What page did he say that he agreed to John Starling being the escrow agent?
Page 50, starting at line 21. When I informed that Mr. Dreiling the funds were not going to be paid, that they were going to be held back by Mr. Starling, we got a three-way telephone conversation. And I initially insisted that the funds be distributed to Ductile, expressing a desire that they were Ductiles, no dispute with Fox. Mr. Starling refused. Mr. Dreiling prevailed upon me. The attorney for Cunningham prevailed upon me that Mr. Starling could hold the fund, Ductile's funds, as far as I knew, so long as I was repaid any tax costs that was attributable to the transaction, which he later testified he kept getting the tax burden of this interest during the time period. So I agreed to that. And the period of my understanding was it was going to terminate if the Barbara Fox issue was resolved. So I agreed to that. There's numerous instances where he indicates, although he reluctantly agreed because it was Mr. Dreiling that imposed on him or someone else, he agreed to it. The fact of the matter is he did not convey anything. The trust agreement prohibits him from suing. We're related to the failure to disperse proceeds to him. Proceeds that...
My notes reflect that at the transcript somewhere between 49 and 55, Cunningham testified that he never agreed to the appointment of Starling as his or Ductile's escrow agent, never recognized him as Starling as Ductile's escrow agent or his escrow agent.
You're misunderstanding it. That is not I was informed by John Dreiling at top of page 50. He talks about, I didn't feel like I legally had the right to pursue, but in fact John Dreiling prevailed on me to have John Starling. Bottom of 50, he says, I insisted that we disperse, but John Dreiling prevailed. On 51, he says that I agreed.
Okay.
I mean, we know it wasn't his choice, but he agreed.
Thank you, counsel.
I know that your time is up, but I do want to ask you one more thing, and that is the point that's made that failure to renew the motion for involuntary dismissal means that you waive the right to review sufficiency of the evidence regarding any of the findings of fact that the trial court made. Those cases do say that, and I don't see any contrary case law. Do you have any brief response to that?
I do, very brief. First of all, standing is a de novo review because it's not an issue of fact. This court has held that it's a de novo review. Secondly, the cases hold that it's the failure to raise a directed verdict, as Judge Evander stated, in a jury trial situation. And although there's analogous cases that say a motion for involuntary dismissal is the same as a directed verdict, there are no cases that say at the conclusion of all the evidence you must renew a motion for involuntary dismissal. And I suspect the reason being is all of those arguments are in my closing, that the plaintiff's case should fail because they've met their burden, so it's essentially the same as the closing that was presented. So whatever magic incantation you want, it's not required. All of those arguments were renewed in the closing, which is the conclusion of the evidence.
Okay, thank you.